Which microphone is requesting a point of personal privilege?
Mic one. Mic one.
Mic one?
Point of personal privilege?
Yes, Mr. Heiss.
I feel I need to respond to Termont. The Mises Caucus has also offered Mike Termont the vice presidential position.
Okay. Thank you, Mr. Heiss.
But UCC commercial code is, if you're smart, you dig into it. It's something that you can use to get yourself out of trouble and regain your personal sovereignty and your financial independence. There's some weird stuff that happens with maritime law too.
Right. Do you think the chair properly supported Chase Oliver under the bylaws? Is that your opinion?
Yes, I think that is.
Oh,
yes.
okay. Well, that's disqualifying.
And so, the answer is take our fucking entire military and put them on our border and secure our border.
Dave was a groomsman at my wedding.
Is getting private funding to be chair, a conflict of interest?
In 2022, as I began to campaign for this role, I compared us to the Israelites wandering in the desert. And I have brought you to the edge of the promised land, and we have glimpsed it. But someone now has to be the one to lead you over the edge and into the promised land. Kind of like Moses, my role is to die on this hill.
This is a CNN tactic that's being used right now, and I think the people who see this video are going to understand that.
Well, thank you very much, everybody, and thank you, Angela, for that introduction.
Hey, everyone, and welcome to another episode of the Fakertarians podcast. I'm your host, John Hudak, along with Jeremy Kantorowicz and our tech guy. So today we have someone I've been speaking with on Facebook a decent amount lately, and we'll get into why. His name is David Pletz. How you doing today, David?
Not bad. How's it going, John?
Good. So, and before I start, David, do you identify yourself as a sovereign citizen, or do you reject that term? Just so I can know what to refer to you as.
So I mean, I look to that website. I usually share a lot, sedm.org. If I would put my bet on anything, it would probably be that website. And they got a few different takes on it. But for the most part, they claim that anybody who mainly sovereign citizen is used by morons. It's an oxymoron, basically. Used mainly by morons. That's what the site says, pretty much.
Okay, and we'll get into some of what the site says and all of that, and we'll talk about that. But what is it? Oh, sorry. I
wanted to clarify too. I'm not saying that like everybody who uses it, like I think they aren't either. Just mainly most people, because they do even on the site have videos of guys talking about it too. So I mean, I ain't gonna completely deny that there aren't people that do talk about it on the site.
Okay, and like I said, we're going to get into some of the nuts and bolts of what we've been talking about. But just regarding the site in general, since you said it kind of defines, or at least is a decent representation of your views, what is it that makes the site trustworthy to you?
It's a nonprofit. I think Andy was on the libertarian group there for a while. He was saying that there was a paywall, but I ended up setting them right on it. It's not actually a paywall. I'm pretty sure they do it to cover their own butts on like the legal side, as well as the people trying to do it. But yeah, it's basically the more information, the more steps you take in implementing it, the more information is unlocked to you on the website.
Okay, and so let's get into some of the disagreements we were having, or have some of the discussion on some of the things we were talking about. And we can talk. We can go all over the place here. I obviously have my specialties, but what do you take issue with that I say about these things? Because just for everyone's knowledge, I don't think this site is legitimate. I think a lot of the arguments are incorrect. So what is it that I say that you think is wrong?
I mean, I kind of said it in the group there a little bit, but it's like, say, entertain for a second that that they are speaking truth, right? And I mean, I obviously believe they are, right? So I mean, take it from that perspective. I mean, someone who, I mean, it almost feels like you're being gaslit, or even like not listened to, ignored, dismissed, especially when we don't really dive too much into it. And I understand it's hard on Facebook to understand stuff, context, and all that. But I don't know. If I had to pick something, I mean, I could definitely go with the Bill of Attainders that I've been getting into recently on the group.
Sure, and we'll talk about that in just a second. But
Informations as well, and how like traffic tickets are kind of like, or basically are informations under common law.
okay, and we'll get into all of that. But when you say to take for granted that the things on the site are correct, I don't think it makes sense to do that, especially when, through my experience and through other research that can be done, you can find things that show that the things on the site are not correct. I know you're going to disagree with that, but I can't just take something for granted that something is correct when I've seen things like this try to be used in court before, where a defendant will try to say, oh, you don't have subject matter jurisdiction. And I've seen what I would generally refer to as a sovereign citizen try to go to trial without a lawyer before. And just to sum it up, it's been basically a complete disaster. But let's go into the Bill of Attainder thing we were talking about. So what are you thinking about?
Before we do jump into that, I would like to add on to that what you just said. I mean, I challenge you to go on and give me any case, or if you could cite any case that implements what they teach and show me that they did get overruled in court, or they didn't get the favor rule. I mean, I would definitely be open to that. You know, I'm open to changing my mind, and I don't completely disagree that it does happen. I know it happens. You know what I mean? I see it all the time too. Maybe not like you do. I see it on videos on Facebook all the time, but I also see a lot of videos on Facebook too where, I mean, it looks like it works out for the people who do it. And I could share a couple with you.
A couple videos, or are you talking about like judicial opinions?
Or at least one video. Just a video of someone who you would definitely say would be a sovereign. I probably might even say he would be a SovCit, but I mean, the court, the judge, pretty much rules in his favor at the end of it. I mean, you could see she's trying to railroad him, and she's trying to lead the procedures on, like lead them on to the procedures that are incorrectly followed, basically, I would say. And he does set her straight in it. He does, and I feel like that's one of the biggest things is, like, most people, they don't try to fight, right? They just take it as what it is. Well, I mean, the court, what can you do? The court, the judge sided against you. I mean, there's nothing you could really do unless you have more information about how the procedures are supposed to work, how the laws are supposed to go, how the spirit of the law, the spirit of the Constitution, or like the spirit of the laws under the Constitution have been in our history. And I mean, it may have changed at one point, but I don't know. I don't know if it changed for the better or the worse. I mean, I would probably say the worse. I don't know. I'm kind of rambling at this point, though.
That's okay. So
Kinda
there's
luck.
a lot. There's a lot there. Regarding your point about any case law, so most judicial opinions would not just say or would not cite this website, even if there was an argument from the website. Like if we're talking about an appellate court opinion, it's not going to say the defendant argued this because he found that on this website. So, I mean, I can absolutely look into specific cases and see if they even reach that level of being at an appellate court with a written order. But I would also challenge you to find an opinion where a defendant like this actually wins at the appellate court level for those reasons. Now, there are times where so-called sovereign citizens will win things. I absolutely agree on that. But most of when a sovereign citizen wins something, it's not because they're saying that we're under martial law or because there's no subject matter jurisdiction or something like that, unless there actually is a legitimate argument for subject matter jurisdiction, but those are few and far between in a criminal case. Usually what will happen, well, it divides into a few different categories. So let's start with something like tickets, because I know we've talked about that before. With a traffic ticket, it is a very minor offense. I mean, there are traffic criminal tickets, but they're usually civil infractions. So
Reckless driving.
Yeah, no, there absolutely are misdemeanor offenses. I mean, you can even get to felonies if we're talking about certain levels of DUI, but it's not a ticket anymore.
I got charged with a driving way too fast once.
Yeah, and you can get that. But with most tickets, they are very minor, and there are a lot of people picking them up. Now, prosecutors, and this is true across the board. I mean, it's probably more true on a traffic ticket than it is on a misdemeanor or felony case, often do not want to have to do a lot of work. So just by showing up to challenge a traffic ticket, even if you don't have an argument, a lot of the times a prosecutor will just say, hey, will you pay this reduced fine with no points? Let's just call it a day, because the prosecutor does not want to have to take the time to respond to a motion or take the time for a formal hearing. And in Michigan specifically, a lot of city attorneys, they're called, who would be doing a lot of the traffic tickets they're not solely prosecutors. A lot of them are taking on a role as a city attorney as part of their firm. Like they might even do criminal defense in another county. They might do civil law. They might do family law, something like that. So most of them are not going to want to waste their time with traffic tickets. They're just going to want to say, okay, can we just get this done with? I'm being paid, or I'm not being paid by the hour. I'm being paid a certain amount per month. I don't want to spend all my time on this because I want to work in other cases. Now, with traffic or even misdemeanor or felony cases, it is possible that when a case is taken to a formal hearing in a traffic case or to a trial in a misdemeanor case, that there could be actual factual issues. I mean, it could be, if we're talking at a criminal level, that the prosecution actually just didn't have a great case. Maybe they actually couldn't prove it beyond a reasonable doubt. It could be at a formal hearing for a traffic ticket that the judge takes a look at what happened and says, actually, I don't think there was any kind of violation here. So just because someone challenges something and says, you don't have jurisdiction based on this, or goes into some argument like that, doesn't mean that that's the reason that they're actually winning the case. It could be for a multitude of reasons there.
Yeah, I understand that, and I get it. I agree. I don't deny that. it just seems like there's something more under the surface. I did want to touch back on that website real quick. So they do have testimonials posted on the site. I don't even think you got to be a member to see that, but you got like a decent amount of people like talking up like how it works for them. And even if when you do become a member, I'm pretty sure they got like a chat section where you can actually chat with a lot of the people. And they do even offer services for some people that they will represent you for free, basically.
Could I add something here? Just so we're talking about reviews here, and I think I know what you're talking about, but just so everyone's aware, PC Optimizer Pro has reviews on their website too, and it's still going to be listed as malware on every antivirus. So don't always believe these member-only reviews.
So what I was going to say, kind of in that vein, was that I did just pull up, I think it's sedm.org/membership/testimonials.htm. I think that's the URL that you're talking about.
Yep.
I am seeing there's not full names. It'll say like J. Dawson, 10/18/2007. I see about 30 testimonials. I don't see any judge's orders saying that a motion was granted based on an argument that's used on the website. I don't see any appellate decisions or any citation to even any cases. And just because a case was cited doesn't mean that it's actually based on what they're talking about. Kind of like how I went into before, there's a lot of reasons a case could get thrown out or pled down. So, I mean, anyone could it's possible that these are all real. But even if they are all real, I mean, some of them are just, we appreciate your ministry and your kind attention. Thank you so much for your help. Your website is such a blessing. Thank you for the information. I am greatly enjoying the book. It doesn't show that the arguments actually worked in court. I mean, some of the people may have not even been to court. They may have just found it interesting. And some of them, maybe they did prevail. Maybe it was like the traffic ticket example where, let's say someone got a careless driving ticket or something like that, and they showed up to challenge it. The prosecutor said, okay, well, you take an impeding traffic ticket for 0 points on your license. And maybe they showed up and kind of gave some of these arguments. And maybe the prosecutor was just going to give them that anyway, because the prosecutor doesn't want to go to a hearing and just wants to get this done with. Because if you're talking about a ticket, even from a financial standpoint for the government, and I'm not pro-government, I'll tell you that, but I'm just talking kind of cost benefit here. If it's like $100 ticket, the amount of money or the amount of taxpayer money that would go towards the judge, the prosecutor, if we're talking about a case where an attorney is appointed, like for a misdemeanor or something like that, the public defender, the amount of tax money that would go into that is significantly higher than what the ticket itself would be. So even from like a cost benefit analysis from the point of the prosecutor, and believe me, I am not someone who is a fan of prosecutors, I don't think they would see that as being fruitful. Now, if we're talking about an armed robbery or something like that, a prosecutor isn't generally just going to throw that out if you show up. And in my experience, you can definitely plead cases down. Most pleas, I would say, that are where someone doesn't go to trial are usually with some sort of leniency, whether it's a reduction in charge or an agreed upon sentence that's significantly less than the maximum or significantly less than someone might expect to get if they're going to trial. And that's that same issue where a prosecutor, they don't have enough time to try all of these cases, because trying a case takes even if we're talking about full-on criminal cases, trying a case takes a lot of work. You have to track down witnesses, you have to draft a strategy, you might want to write out questions, or at least the topics for questions you're going to ask. You have to subpoena witnesses. So there's a whole lot that goes into it. And then for that prosecutor, there's still a chance, even if they think they have a great case, you never know exactly what's going to happen in front of a jury. So the way the justice system operates right now, and I think this is wrong because I think the only reason the justice system can operate like this right now is because people are coerced into pleas, for sure. But if every case was taken to trial, there would be such a backlog of cases that the court system would just be absolutely jammed. So it's not always, oh, I'm dropping this case, or I'm reducing the charge or reducing the fine if we're talking about a traffic ticket, because the defendant had a great argument or a great motion or something like that. A lot of it is just time management.
Yeah, and I like I said before too. I don't really deny it. I agree with you on that. I understand it. Drew, the guy I kind of gave an example for you. He pretty much told me the same thing, and he did talk to Andy as well on the group. I tagged you both in his post on his page. I don't think you responded on that.
Yeah, I didn't get the tag.
I don't know if you've seen.
I don't know if it was an issue. Was it on his actual Facebook profile?
It's on his profile page. Yeah.
It might have been that it was friends only. I don't know.
I don't think so, because like I said, I tagged Andy on it too, and he ended up having a little. I mean, they went back and forth a couple times, a little bit, and then I took over from there. But I mean, I don't know. Let me pull up the page real quick. Let's see if I can.
And I'm not going to. And this is up to you if you want to talk about his full name or anything. But I'm not. I know who you're speaking about. I'm not going to throw his name out there unless he wants it out there. But I did, and this is publicly available. I did not look up anything that requires someone to be a lawyer or anything like that. You can go to the Michigan Court's website and look up some cases. He has definitely gotten a lot of tickets thrown out or reduced. But that does not mean that was based on, it's actually, I can actually drive without a license plate. It's, unless I can see some sort of court transcript or order from a judge saying this was dismissed because the argument that the respondent or defendant or whatever you want to say made in the motion was correct and there wasn't jurisdiction or there was some error here, it's hard for me to believe that it was because of these arguments. And I did find one of the motions he submitted, I think it was in 2022. And for someone who's not an attorney, I mean, it was an impressive argument. Absolutely. It seems like he's got a decent head on his shoulders and everything and all of that. But I looked at the motion and some of the court rules he was citing to, the paragraphs he wrote out, and I'll see if I can try to find this motion again. You might know what I'm talking about. It was a brief in support of a motion to dismiss. But he was specifically citing two court rules that actually explained why his motion was incorrect. I believe it was MCR 2 something, where it says that the rules in that section govern civil cases unless there is another section that says otherwise. And there is another section that says otherwise. There's a section about traffic tickets and traffic citations and all of that has a different procedure. And I'm not expecting you to have a full legal response to that. I mean, I don't even have the motion pulled up, but just from what I've seen, and again, it's cool that he was able to put something together and do some legal research and things like that. But that seems to me to be a case where a prosecutor sees this motion, and even if the motion is just completely wrong, the prosecutor doesn't want to take the time to fight with someone over a $150 ticket when they could be billing $300 or $400 an hour, especially if they're if they're an appointed city attorney or a retained city attorney where they have another practice. It's just not worth their time for them to do a full hearing on this or a full motion response or something like that.
Right. Yeah. I mean, like I said, I agree completely. I ain't gonna disagree there. He admitted himself. I mean, I can't argue with him over what he does. You know what I mean? But yeah. I mean, going back to like how I said, I think there's something deeper. Like from what he was saying, and to your point about jurisdiction, I mean, I wasn't really arguing the jurisdiction too much when I was trying to make these points, like about him, because he himself doesn't argue that too much. He admits it himself, like he doesn't really argue any of like the sovereign citizen type style arguments. He said when I asked him for advice on how he does it, he told me basically read the rules of civil and criminal procedure and learn them, make sure you know them, and be able to basically spot when exactly they're drifting off from them, which he maintains that they always do. I mean, maybe he meant majority of the time they do. I don't know. I think I could probably agree and say maybe they always do. Maybe not 100%, but I do think that I kind of lost my train again.
No, that's okay. Happens to me. So I want to touch on a few things. Oh, do you have what you want to go with?
Yeah. So. Yeah. So I was talking about the rules of civil and criminal procedure. So yeah. So like one sovereign citizen argument I could definitely speak on before I even talked to him and got this advice to go dive into the rules of civil procedure was that they never swear under oath to the crime or the civil infraction that they witness, which is under the rules of civil procedure that it's mandatory. And he and I kind of told him that. I was like, I know that. And then like I was also asking for like further clarification kind of from him, like helping me kind of go through them, hold my hand. But yeah, he was saying that like look at the citations, match the citations up to the rules of civil procedure, and you can see that they're missing a lot of pertinent info that by law, by the rules of procedure, they're required to have. You know what I mean? I mean, what do you say to that?
So let me touch on a few things just before I get to that, because it's kind of going to feed into this, and I'm absolutely going to address your point there. So as far as learning the rules of criminal and civil procedure, that's absolutely useful to have, I think, for anyone, for a lawyer, for anyone who's involved in court proceedings. But just reading the rules is not enough. I mean,
like at most until your court date, you're going to have like what, a few years to read or a few months to read all of these rules and procedures, where you can hire someone who's taken like years to study them.
So my whole thing with that is I don't really trust anybody but myself. I mean, it's part of the reasons why I really don't even file taxes usually. I mean, I don't understand it. I think from what I've read, it looks wrong to me. It looks unconstitutional.
But they'll give you a lawyer.
I want to address what I was talking about real quick, because I had a whole thing I was trying to get to.
But I did want to talk too. I was denied a lawyer one time for criminal proceeding, driving without a license, And I think I even still have a bench warrant for that one. I told them I wasn't going to pay it because it wasn't me driving when they issued the ticket.
Okay, so let me touch on a few things there because we went over a lot of stuff, and remind me if I miss anything that you ended up saying. So what I was trying to say with the rules of criminal and civil procedure not being enough is that because we live under a common law system, you need to look to prior judicial opinions to see how those rules are actually interpreted. Because you can see rules on a page and you can think about how they actually should be interpreted or how you think they should be interpreted. But precedent does count, and I mean there's different levels that count more than others. If we're talking in Michigan, I mean the Michigan Supreme Court precedent controls over the Court of Appeals and things like that. So case law is, I would say, even more important than the actual statutes themselves, because it will tell you about specific situations where these rules were interpreted previously, and it will give you a good idea of what a court will do now. Now, a court can deviate from that, and case law can be overturned, whether we're talking about the appellate court level, the Michigan Supreme Court level, federal appeals courts, the United States Supreme Court. But case law is extremely important in interpreting the court rules or any kind of statute. And again, what you said about them not following the rules of criminal and civil procedure, I mean, it is possible that you might find technicalities sometimes. And first I'll say that definitely there are times where someone has screwed something up. And there are times where someone has screwed something up if it's bad enough to the point where a case may be dismissed. But a lot of little things are not going to be enough to get a case thrown out. And you can see that based on the case law. Like, if we're talking, and I know you wanted to get into information, but in a charging document, when the date is slightly off, there's case law saying that is not going to be enough for a charge to be thrown out, or that not to be enough to overturn a jury's verdict if the date is slightly off on the information or the indictment or something like that. So just because there's a slight deviation from the rules of procedure doesn't mean there's actually going to be a dismissal or even any kind of relief. I mean, a lot of times courts will look to whether there was actually prejudice to what's called prejudice to a party or not, and whether that prejudice can be remedied. So for something like a date, or even for things like, I've seen cases where a witness list is filed late for a trial, and the rules say something like it has to be within X amount of days before the trial, the witness list has to be filed. And then let's say the witness list is filed 5 days after that. There are many times where a court, and I would say the majority of the times, where a court will say, oh, well, there's no prejudice to the other side based on this. They had notice based on seeing something in the police report or already being aware of this witness. So the court's not going to take any action here. As far as the driving with a suspended license you were talking about, so it depends state by state. I used to practice in Florida before I practiced in Michigan, but there is federal case law on this too, about when you are entitled to an attorney. The deal in Florida was that if the judge would certify that the defendant would not be getting what's called an adjudication, because we had something called a withhold of adjudication in Florida that looks better on a record, and the judge would certify that there'd be no jail time, a defendant would not be entitled to a public defender. Now, I don't know the Michigan rule off the top of my head about what the cutoff is. I know some states it's if you're facing less than 90 days in jail or something like that, you're not entitled to a public defender. Or if the judge says that he's not going to sentence you to jail. You're not entitled to a public defender. I mean, in Florida, I saw cases where where parents were charged with truancy violations for their kids. And I think the maximum on that was like 60 days in jail. So the judges would not give the parents public defenders for that until they violated their probation. Then they would be entitled to a public defender at that point. So there are times where someone isn't necessarily entitled to a court-appointed attorney, but it is kind of the exception to the rule. It's usually for very, very minor cases in the grand scheme of things.
Right, but you would agree that that's like criminal jurisdiction, right?
What do you mean by criminal jurisdiction? Like what are you referring to? That what is criminal jurisdiction?
Driving without a license.
Yeah, in a lot of states that is a criminal traffic offense. Absolutely.
And so the right to lawyer, that applies to both criminal and civil.
So the right to retain an attorney applies to both, but the right to be appointed an attorney if you can't afford one applies to most criminal cases, but there are exceptions.
Right. So, but you're saying basically driving without a license could be the exception, but you're not.
Yeah, that could, depending on the specific statute and depending on the specific state.
I think the judge did say like there wasn't going to be like a chance of imprisonment, like you did say.
Yeah, and I don't know the Michigan rule off the top of my head because I haven't dealt with that because I haven't been a public defender in Michigan. I was a public defender in Florida. But there is, I believe, the federal case law is actually, I forget if it's 6 months or a year, if you're facing under that, I don't think you're entitled to an attorney for the maximum. That could have changed. I think that was, I don't remember if that was Gideon v. Wainwright or if that was another case. But there are exceptions for minor criminal cases where someone is not entitled to a court-appointed attorney. Now, they can still hire an attorney. They just can't necessarily have one appointed for them.
Okay. Yeah, I wasn't too sure on that one.
Yeah. Is there anything I didn't touch on that you talked about? I might have missed it. I know we were kind of going back and forth for a bit.
I don't think so. I still haven't looked up that his page, but I did want to touch on so like you were saying about like small like mistakes in the ticket maybe. So like I'm not really contending that either. I'm more or less like from what I've read on the rules of procedure and from what I get tickets all the time for speeding. I speed all the time. But from what I remember comparing it to, it looked like there was a lot of stuff missing, like stuff like that would almost seem intentionally like taken off or left off, you know what I mean? For instance, the attorney's address and the officer's address is supposed to be on the fine, if I remember right. Now, when I was looking at my past tickets, it wasn't on there.
Well, I don't think the attorney's address would be on there because the attorney isn't retained at the time.
Prosecutor, the prosecutor, my bad. State prosecutor or magistrate, whatever.
Well, so a magistrate would be different than a prosecutor, but I mean, a prosecutor might not even be.
But sometimes they like take over, right?
Are you talking about like a magistrate judge, or are you talking about a prosecutor? Because a magistrate judge will handle.
No, I'm saying like, sometimes the prosecutor will take like the magistrate's position. It has been like I went to a ticket before and that was the case. I'm pretty sure that was the case. I don't think he was like a judge or a magistrate or anything. I mean, I could be wrong though. I'm not 100% sure on that.
Was it that you were meeting with a prosecutor? Because sometimes, depending on the jurisdiction, a prosecutor will agree to meet with a person who has a ticket. They will sometimes have that be the first court date before any kind of hearing is set. And a formal hearing is like the equivalent of a trial, but it's in front of a judge for a traffic ticket. And sometimes for like what's called a pre-trial hearing, or you'd call it a pre-formal hearing. The prosecutor will talk to the person who got the ticket and see what they're willing to do and see if they can work something out. Because again, it does make sense, even from a financial standpoint or from a prosecutor not wanting to do extra work standpoint, to try to get someone to pay a lessened ticket. It makes more sense than taking or doing a full trial and having to subpoena the officer and the prosecutor risking the officer not showing up. As far as things on the ticket, I mean, a typo isn't going to get a ticket thrown out generally, or a small mistake on a ticket isn't going to get a ticket thrown out. Now, if it's completely someone else's name, that could be enough for a judge to throw a ticket out. I mean, if it's a completely different make of the car than what was driven, I mean, that's something like that is possible, something that actually substantially changes things. But I don't think the officers address being incorrect on a ticket, as long as the person who got the ticket would be able to identify the officer through their name or through contacting the police department or something like that. I don't think that would be enough to get a ticket thrown out. I mean, it's possible a prosecutor might just agree to it because they might not want to fight it, like I said before, because it's a matter of convenience. But from the actual, if the prosecutor actually wanted to go forward with it, generally that's not going to be something that's enough to get a ticket thrown out. There could be a judge who does it and says, basically decides they know the prosecution's not going to appeal that because it's not worth the time, and the judge might just do it even though they know it wasn't technically within the bounds of the law, because that will happen sometimes. But in general, by the letter of the rules, that's not usually something that happens.
Okay. But now entertain for a second that I am right, that the rules of civil procedure do say that the prosecutor's address and the complainant's address is supposed to be on the fine or on the citation or on the court summons or arraignment. And it wasn't there. What would you say to that, basically? You know what I mean?
Well, first I would ask if the specific court rule or statute you're citing has anything that says what relief a defendant is entitled to or a respondent is entitled to in that situation. I'd also have to look at the case law for that, because there are very specific situations. My guess is something like this has probably come up before, that specific situation, if there's one thing you're talking about that's left off of a ticket. But like I was talking about before with how the rules can kind of bend if there's not prejudice to a party, it's doubtful to me that if the prosecutor actually wanted to go forward with it, and if the judge decided that he didn't just want to dismiss it knowing if it was appealed, he knows he would probably be wrong. I don't see that being enough to throw a ticket out to say that there's prejudice to the party, because there are all kinds of little things that go wrong. And there's case law on this, if you look into what I was talking about regarding witness lists, where there have been cases where a prosecutor in a criminal case hasn't even put someone on their witness list and then gets them in at trial because the judge finds that the defendant was already aware of that witness because they were listed in the police report somewhere. So just because there's a rule saying what someone is supposed to do doesn't necessarily mean that the remedy is going to be a dismissal of that case, or even that there's necessarily going to be any remedy at all, unless a court finds that there's actually prejudice to the opposing party based on that mistake.
Okay. Now, I mean, I could touch on the prejudice of it. Would you want your address on a summons or arraignment against someone who's like me, maybe a little more extreme, and might actually like commit violence against someone? Would you really want your address on that?
So you're arguing that the prejudice to a person who, I just want to make sure I'm understanding the argument before I touch on it. You're arguing that the prejudice to a person who gets the speeding ticket is it with the prosecutor's address left off of it, is that the person who gets the speeding ticket wouldn't be able to have the address to use violence against the prosecutor?
No, not exactly. I'm just saying that it's like, I think that's why they intentionally leave that information off, even though they're not supposed to, I think. But no, the prejudice, I would say, I mean, shouldn't you you should have the contact info of the prosecutor that is making the claim against you, right?
I mean, absolutely, you should know. You should know who's prosecuting you, but at the time a ticket is written, I mean, you're not even necessarily going to know who the prosecutor is, even if they list the city attorney in charge, or if you're talking about a state case like the district attorney or something like that. That's not even necessarily going to be the prosecutor that's handling the case. So by the time you get to court, you will have been able to find that information. I mean, the prosecutor will be there in court. You are allowed to contact the prosecutor's office and say, hey, who's handling this case? I mean, they often won't speak to unrepresented defendants, but on something like a traffic ticket, they might. If you're represented, they definitely will not speak to you, because there are rules of professional conduct saying that they can't try to go around the defense attorney if you already have an attorney. Because the idea there is that they don't want the prosecutor whispering in someone's ear, getting them to take a bad deal. But not having it on the ticket, I mean, maybe if you didn't know, I could make an argument if you didn't even know who wrote the ticket, if you didn't know the officer's name and you had no way of finding the officer's name, I could make the argument there. I don't know what the case law says on it. I could make the argument that it doesn't allow you to look into whether the officer is trained in whatever he's ticketing you for, like whether he's trained in accident recreation if there's an accident, or whether his radar was properly calibrated or something like that. I could make that argument there if you had no way of finding it. But even, let's say, the officer's name was left off the ticket originally, I would venture to say that a court would probably say there's not prejudice if you were able to find out later who the actual officer was, and if you had enough time to actually do that kind of research into the officer.
Yeah, that's what I was going to bring up next, since you said the attorney would come in later. That kind of information was the officer. But yeah, I mean, it's kind of like the same thing with the officer too, though, right? You should be able, you should have their information. You should be able to maybe contact them, send them a letter, seeing if they even have an attorney, or to get their attorney's information. Even, you know, I mean, I realized, like you said, you could do that through the courts probably.
So the officer himself, I mean, in his official capacity, or in the case at least, is not going to have his own attorney like in the speeding ticket case, because it's going to be like a city attorney, a district attorney, someone like that handling the case. If you're talking about suing the officer, there may be that the officer has an attorney through the police department, or an officer can retain their own attorney. but you're not necessarily going to know who the attorney for the officer is until you actually threaten some kind of litigation against that officer, or until you actually file a lawsuit against that officer, if that's the route you're talking about.
Yeah, I mean, it's been a minute since I read them and looked at them, but I wish I would have brushed up on them.
That's okay.
I mean, we could go through them, but I'm sure it would probably take a minute. And
If there were specific ones you wanted to talk about, I mean, I'd be happy to talk about them. But that's up to you. I mean, we can cover whatever you want to cover today. I know there were some other things you said you wanted to touch on too.
Yeah, for sure. I think there was one thing you might have missed though.
Sure.
On the oaths under civil procedure. What would you say to that, rather than as far as like prejudice going?
What part of civil procedure? I didn't hear the first thing you said.
So if I remember right, under civil procedure, a cop that catches you for speeding, say, is supposed to take it to a judge or a magistrate, and he's supposed to swear under oath that he witnessed the crime or the civil infraction. To my knowledge, I don't think they ever do that. I mean, like I said before, I was
like, John, don't they submit an affidavit, and isn't that what it is?
Yeah, they can submit an affidavit too. I'm trying to remember exactly which statute or court rule you're talking about. I know there is one about that says that if the ticket isn't, if responsibility isn't accepted, then the officer has to go in front of a judge. Let me see if I can find that court rule for us real quick.
okay. And when you say responsibility isn't accepted, that's basically a not guilty plea, or not
Correct.
guilty.
So if in the case where the person who gets the ticket is challenging it, so if they're not just paying the ticket, or if they're not agreeing to,
I figure that police attest to the charges in courts all of the time, or something like that. They either submit it in writing or come in the probable cause hearing, I guess.
Yeah, so
it's supposed to be done like they're like, it's I think it's supposed to be for like them to stop them from like lying. Like basically they're swearing under oath, they could be held liable at that point, right, for like perjury.
I mean, lying in any court documents is going to get you perjury.
Like what they said, basically. What did you say? Sorry.
I mean, lying in any court documents is going to get you perjury. So if a cop is sending in documents or attesting to something that is factually untrue, he's going to get perjury either way.
But I mean, there's like lots of instances in court where like there's many falsehoods that are spread in court. Like I think I forget what it's called, but they bring in like an expert basically to come in, and it's usually court appointed, I think, and usually they'll go over certain things, but a lot of the times they're not always 100% accurate. But they don't.
If that's the case, though, if that's the case, your problem isn't with the courts; it's with the experts.
So a couple things I wanted to touch on there, just while I'm trying to track down this this court rule real quick, so I can find the actual.
Supposed to be setting the standard for proof, evidence, truth. You know, all that good stuff, rather than the experts. I mean, that's what we're supposed to be.
A few things I want to touch on here. So, as far as what you were saying about the experts and perjury, it is very common that both the defense side and prosecution in a criminal proceeding, or the plaintiff and a respondent in a civil proceeding, will have experts. They are not necessarily lying. They might have differing opinions. The way to prove that, or the lengths you have to go to prove perjury, you actually have to show that they were knowingly lying under oath, and you have to prove it if it actually goes to trial, you have to prove it beyond a reasonable doubt. So there is a very high standard there for actually getting to that level, because even if you think someone is lying, it doesn't necessarily mean that you can prove to that level that they are lying. You also have to take into account that it would generally be the prosecutor's office that's bringing charges against someone. I mean, you can talk about a local prosecutor's office or the attorney general's office, depending on the state or something like that. But, and this is wrong, obviously, but the prosecutor is generally not going to go after a police officer that they work with all the time unless there is a very rock solid case and there's enough pressure on them that they have to, because a lot of times it's just completely explained away. Like I've definitely seen officers lie under oath before, for sure, many times. But can I prove beyond a reasonable doubt that they lied under oath? I can think of maybe one instance I might have been able to, but I'm not the one. I can't bring charges. The decision is from someone else, and most of the time, you're not going to be able to prove that just because of such a heightened standard there. It also is the case, at least on most traffic tickets I've seen, that there is a section saying that the police officer signing it is declaring under penalty of perjury that the information included is truthful to the best of their knowledge. There could be, you might be able to show me a ticket that doesn't have something along those lines, but generally that's what I've seen. I haven't seen one yet. So they already are saying under penalty of perjury, as much as that does, that they are telling the truth there.
Yeah, I'd have to look through my tickets and bring it up to actually get the evidence. But yeah, I don't know. I do agree. I do know that it's really hard to prove perjury.
Absolutely.
But yeah, that is definitely. I mean, it could definitely be perjury, right?
Oh yeah, I mean, if the cop is knowingly lying under oath, or if anyone's knowingly lying under oath, that's perjury. But you got to show that they were doing it knowingly, and that it has to be a lie, not just an opinion,
or not
and
just.
Yeah, and you have to, if you're going to actually try it, and it's not going to be a plea. I mean, you're going to have to convince a jury that this was a lie and it was done knowingly.
Right. I could bring up the Johnny Depp case.
Wasn't that a civil proceeding though?
About no, I'm getting into like I was adding to the perjury. So I mean, like, what's her name? I forget. Amber Heard.
Yeah, it was Amber Heard.
She was definitely lying under oath, and like if you go back on her word, you could definitely say that she intentionally was misleading or lying. You know what I mean? But she didn't catch him either. She didn't catch no perjury charges for that. You know what I mean? I just think, it can happen, right? But not always. It doesn't.
Yeah. So, and I'm going to touch on the perjury thing in a second, and I would basically agree that it can happen, but not always, because there is discretion there on the part of a prosecutor whether they actually want to pursue it. I mean, it's just like how there are a lot of crimes or civil infractions committed every day that don't go anywhere, and it's not always because someone doesn't know about them, but there are a limited amount of resources for the state to go after people, and they're not going to prosecute every single crime or every single possible crime that they could find or every single civil infraction. Now, I did just find a statute that I think might be the one you're talking about. It is MCL 257.744. This is a Michigan statute. and it talks about how it says that if an officer I'm not going to read it verbatim, but it says that if an officer issues a citation for a civil infraction or a parking or standing violation, the court can accept an admission from the person who got it, or a denial of responsibility without the necessity of there being a sworn complaint. But if the person denies responsibility, like after the denial of responsibility has gone in, then it says, and I'll quote this, further proceedings shall not be had until a sworn complaint is filed with the court. Now, I would argue that, or I haven't seen this challenged before, but my best guess right here, just based on what I've seen and what I know, is that the part of the ticket that says that they're swearing to it under the penalty of perjury would likely qualify as being a sworn complaint under the statute, because that's exactly what they're asking for. I mean, it's just like how in a criminal case in Michigan, it's initiated with a complaint. It's the same thing where they're swearing that this is the case. It's just like a warrant where they're swearing that it's the case too. They can do that via a signature.
Right. Yeah, I don't know if I ever seen it on there. I'd have to double look. I definitely looked through it, but I did want to touch on. I did want to say, so I mean, even if, I mean, so like your contention basically is that it's not, it has nothing to do with jurisdiction or citizenship or anything like that, but that it's just too much of a hassle at times for most people to want to, or to have the motivation to pursue.
If we're talking about a traffic ticket or something like that, yeah, I think that's generally the case with a prosecutor because of the caseload that's there, because of possible motions that could happen, because of having to hold the hearing. Because even if a prosecutor,
they also got the credibility too, right? That they need to uphold.
Say that again?
They also got like their credibility.
Yeah, but I mean, I've seen prosecutors do things that definitely make me question their credibility. But as far as a ticket that's something minor, I mean, you got to think that even if the prosecutor thinks, or even pretty much knows 99% chance they're going to win it, they don't necessarily want to have to do all the work for every single case, to, especially if you're talking about a traffic ticket, and to take that to trial to a formal hearing, for a traffic ticket, because they still have to subpoena the officer. They may have to subpoena witnesses. They have to review the things in the case. They're going to have to actually get to court, do any questioning of any witnesses or the officer, maybe the person who got the ticket. So there's a lot that goes into that. I mean, even in misdemeanor and felony cases, you can see that, where a lot of the time an offer will get better, a plea offer on a criminal case will get better right before trial for a couple of reasons. Sometimes it's because the prosecutors reviewed the case and they realized that there's a decent chance they might lose, or maybe even they think they are going to lose. But sometimes it's just because they don't want to have to take it to trial, because trial could take, I mean, depending on the type of case you're talking about, it could take a day, it could take a week, it could take a month, it could take 2 months. It's a lot easier for a prosecutor to just say, okay, just take this. It's something, I get my conviction, and there's some kind of punishment, rather than taking the risk of taking a case to trial and ultimately losing. I mean, that justification is the same reason that a defendant might take a plea deal, is that they know they might have a chance to win, or they think they might have a chance to win, but if they're being offered 12 months of probation, and if they lose, they might be facing 10 years in prison. I mean, I can't blame them for taking a plea deal there, even if they think they have a good chance to win. And that's not something I agree with system-wise. I think it's messed up how the criminal justice system has basically turned into a plea churning factory. But that's the reality of what things are right now. And with one single person isn't going to be able to change that. So I could totally respect a defendant saying, you know what, I'm not going to take a plea. I think this is messed up. They're trying to guilt me into this. I didn't do this. They should have to prove this. Completely agree with them there. But I also understand why someone might just want to take a plea, even if they're not guilty of something, just because the prosecution is threatening sentence enhancements over their head, or they've charged them with something that is probably much higher than they should be charged with. I see that all the time.
Right.
Yeah, I mean, if I could have my 5 cents real quick. A lot of the sovereign citizen stuff that at least I see online is based on around the idea that you found the GTA cheat code to the U.S. judicial system, and it's and I wish that, you know, sometimes you wish it was that way, and you wish that, you know, there were those technicalities, but you have to think of it this way: this is not GTA 5. This is a video game that, when you count the common laws of England, has been around for thousands of years. It's been making patches. All the cheat codes are gone. They've been gone for a long while. Like, they're gone. They're out the window. The only cheat codes we got left is, do you have money, or do people know you? That's it. And those are the only 2 cheat codes. That's all we got.
The thing on that too is, I'm curious, David, for your take on this, on kind of like a higher level, not talking about a specific statute, but if there was some kind of cheat code like what Skylar was talking about, like to get out of pretty much anything, an attorney would be able to make a killing just doing that over and over. I mean, they'd have every single client coming in, and they'd, like, if I somehow learned of a cheat code to get every client out of something, I'd probably be a millionaire within a few months, because everyone would want me there if I was the only one who knew it, and then everyone else would be using it. But what doesn't make sense to me in a lot of these proceedings, or with a lot of the sovereign citizen arguments, is that it seems like, and correct me if this isn't your argument, but just a general sovereign citizen argument I've seen, is that it's kind of like there are secret buzzwords or secret things you can do that judges don't want you to know about, but they have to listen if you use the secret words or if you use the correct argument, even though it's something that's trying to be suppressed. Because if it's something that's secret like that, first of all, attorneys would be taught that. Attorneys would know that. They would learn it in law school. I can tell you, we did not sign an oath to keep the secret rules under wraps. But also, if it's like that, where a judge can break the law unless someone just says the code words or does the secret argument, then what's stopping that judge, an appellate court, or the Supreme Court from just continuing to do what a sovereign citizen says is breaking the law, even if the person uses the right words or the right argument?
I'm not sure I quite follow completely on the question. Are you saying like basically if they can rule a traffic ticket to be unconstitutional for whatever reason, then they could rule, say, murder or something one of their buddies committed?
So I think the cheat code you're talking about there is jury nullification, and that cheat code's been addressed too. Like,
no, I'm not saying it's a cheat code. I'm saying, is that the question? You know what I mean?
No, let me try to rephrase it a little bit. So let's say that, and a sovereign citizen argument I've heard a lot is that if you say a specific thing, like say you say I'm challenging subject matter jurisdiction, I'm a citizen of the Moorish whatever. I've run into the Moorish sovereign citizens before.
Or driving, right?
Yeah, if you're saying I'm not traveling, or I'm not driving, I'm traveling, something like that,
right?
Then the judge just has to dismiss it.
Right. Yeah, that is a lot of their arguments, and I'll agree with that. But I mean, I don't agree with the argument. You know what I mean?
Okay, because if a judge can just disregard the law,
I do want to
don't mention that.
So I'm not really. I think like the big root cause, or like I don't know how exactly to explain it, but so like I mean you hear it all the time in conspiracy theories, right? They change the definitions. I mean, you could even look in Black's Law and you could see like over the years how the definitions change. Sedum.org, they basically say it's like a double speaker of some sort. Like I think I brought it up in the group recently. So like, and I think I brought up a couple different points to you in the group maybe not recently, but some recent, some not. So like trial with jury versus trial by jury. And then you also got like the right to be represented versus the right to counsel.
And what do you think the difference is between?
They sound like the same thing, right? They sound the same, but like if you take them to their logical conclusion, but just by like the definitions or even the legal definitions, it might seem that, or it might be in fact that they are completely two different things. You know what I mean? What would you say that trial by jury versus trial with jury is the same thing?
I mean,
yeah, those are.
I need to know what you were
Yes.
saying first, but generally, yes. I mean, are you saying that there would be a trial without a judge?
The judge could be present. I've shared a lot of screenshots in the group about it. The judge could be present, but in civil jurisdiction, usually the judge just uses the jury as like an advisory for like to advise the conscience of the court, basically.
Well, if we're talking about
railroad the jury basically and like dictate how the rules are operated.
Well, so like a jury is the fact finder in a case. You are entitled to, if we're talking in a criminal case, you are entitled to a trial by jury, and in a certain amount of civil cases, if we're talking monetary damages based on the 7th Amendment and the incorporation of that, you are entitled to a jury. But if it's a case asking for like an injunction or an equity case like that, you're not entitled to a jury. That can be a bench trial. But in terms of there actually being a jury, I mean, the judge is there for, let's talk about like a criminal case for a second. The judge is there to make the legal rulings as far as what evidence is allowed in, what
basically
questions. Sorry?
Basically a referee, right?
Yeah, the judge is supposed to be a referee, and then the jury is supposed to be the fact finder. So the jury is supposed to decide what actually happened, and the judge is supposed to interpret the law, because the idea there is that the judge knows the law better than a person on a jury would, as far as like the ins and outs of the rules of evidence.
Right.
John, can we call it a trial plus jury so it's more inclusive to all prepositions?
Sure. we can call it whatever we want.
Thank you. That way, I don't want to have any confusion there. I don't want any prepositions to get in the way.
But I mean, I don't think I fully understand what you're saying about a difference between a trial with jury or a trial by jury, unless you were saying that there wouldn't be a judge, because a trial by jury, there is a judge, and the jury is the one who makes the ultimate fact determination. Now, there are times where there are times where verdicts can be found to be unreasonable if we're talking about like an unreasonable amount of damages, like in a civil case. But that's a legal argument, because there are times that there are caps on the amount of damages that can be put in for something. But as far as like guilty, not guilty, I mean, the only time on a criminal case that the judge can, at least in general, that a judge can weigh in like that is if the judge decides that there is not enough evidence for a reasonable juror to be able to convict, and that's actually a protection for the defendant. There's different names in different states. It's called a judgment of acquittal some places, but the idea there is that after the evidence is presented, if it's so weak that the judge rules that no reasonable person could find this person guilty, then it doesn't even go to the jury at that point. But a judge, unless you're talking about a bench trial, a judge isn't going to be able to say, oh, actually, this person's guilty. We don't even need the jury to weigh in anymore. Never mind.
Yeah. No, so what I'm trying to say is like, just trying to look for the little screenshot I got, but no, so like the way I'm taking it, a trial with jury is basically an illusion of a trial by jury, meant to fool people into believing that it is a trial by jury when it's really a trial with jury. And the distinction I'm making from that is basically where the judge isn't the referee. He acts outside of like the authority that I would say he's supposed to have. I mean, maybe not by the statutes and everything like that.
Can
but,
you give me an example?
The spirit of the Constitution, I would say for sure. So like, so have you ever seen Trial of Chicago 7?
It rings a bell. I don't think I've actually seen if it was a documentary or something like that. It does sound familiar to me though. If you want to go into
so like a lot of the times, I mean, I'm sure you've heard of it before. The judge will like stop the defense from releasing like pertinent information that could even like lead to like a innocent conviction. Well, not a conviction, right? But like an innocent ruling.
Yeah, a not guilty verdict or something like that. So as far as that goes,
I would say that would be the judge stepping outside and say it's criminal law. So like they aren't really supposed to. Like, I don't know, like under the Magna Carta, like the grand jury swapped with the king on authority. Well, it wasn't there before, right? But so the grand jury superseded the king during the Magna Carta. So like I take that as the judge is supposed, like we said, just basically supposed to be a referee. The jury should be the one like able to direct the trial. They should be like in any meeting with the judge. I don't know. I mean, like, I understand, like you were saying before, prejudice. There's prejudice involved at times, but I feel like there's at times there is not prejudice. You know what I mean? If you were to watch the Trial of Chicago 7 on Netflix, it's actually a legit movie based on real events, protests of the Vietnam War. They kind of put on like a political show trial for them, trying to stick them with like some obscure law. But they do that in the movie, and I have heard of it done outside of that before too.
Okay, so there are definitely times where people get charged for things that people don't usually get charged for, like with an obscure law, for sure. I mean, I've seen it before.
Right.
As far as what you were saying about trial, so part of the judge's job as the referee is supposed to be to interpret the laws. And part of that is the rules of evidence. So there were rules passed by legislatures and signed by executives about what information is allowed in at a trial. Now, I definitely have disagreements with some of the rules of evidence, with many times with the ways that the rules of evidence can actually be put into place by judges. I think there's times judges get them wrong. I mean, I'm having a bunch of them pop into my head right now on trials I've even done myself where I've known the judge was wrong and they ruled the wrong way. I mean, and there are appeals that can be used based on that for sure. I don't want to go off on too much of a tangent about the concept of harmless error on appeal, because that can be a thing too, and I think that can wrongfully shoot down a lot of appeals. But judges are supposed to only allow evidence in that's going to make a fact more or less likely, or a legally operated fact to be more or less likely to have happened. There are also things in the rules of evidence about prejudice to parties and about using what's called propensity evidence. And there are times that this will hurt a defendant, and there are times I disagree and think it shouldn't be kept out because I think it hurts the defendant too much, or I think the judge made the wrong call. But then there are also times where the evidence being kept out will actually help the defendant. One example with the thing I said about propensity evidence is, let's say someone just has lived a life of violent crime or something like that, or they did when they were younger. Let's say in their 20s, they went around committing all sorts of batteries, assaults, robberies, all that kind of stuff. And then they're 60 years old and they get charged with armed robbery. So under the rules of evidence, and there are some exceptions, but it would take me a while to teach them, because even a lot of attorneys, I feel like, don't always fully grasp the rules of evidence there. But generally, but generally the prosecution won't be able to bring in the fact that the guy committed crimes in the past to show that he committed crimes today. Because even if it could be considered to be relevant, some people might consider it more likely to show that he committed it than that he didn't. It's so prejudicial to the defendant, and it allows the prosecution to just be like, see, he did it before, it means he did it this time. That argument is so strong and actually really doesn't prove anything, that the rules of evidence have been put into place to keep things like that out. So my guess is what you're talking about is a ruling on something on the rules of evidence. Like I said, there are many times I think judges get things wrong on that, but I also don't think that a jury would be able to make a ruling on that. And there are things that a jury could hear, even with what I talked about, like a prior criminal record, that could be so prejudicial to a defendant in particular that if they were to hear it, even if they thought, oh, actually, look at this rule, we're not supposed to consider this. But if they were to hear it and even know that, it's hard for them to get that out of their head. Because even if they're told they're not supposed to do that, they are not supposed to, or they're supposed to disregard that, it's hard to see it actually happen in practice.
Right.
So as far as the trial by jury thing, I mean, I would agree that there are times judges overstep their bounds, and there are times judges make terrible rulings. And I've also seen states with certain rules of evidence that I think are wrongfully prejudice defendants and don't allow them to bring in certain evidence. But I also do think that there need to be rules of evidence, because otherwise the situation I'm describing could come in. There could be a witness who comes in and just says, oh yeah, I saw that guy rob a bank in 2004. So yeah, he's definitely guilty of this rape charge. He breaks the law all the time. I definitely think it makes sense to keep something like that out.
Yeah, I agree too. I agree, and like I said, I understand a lot of the reasoning behind it. My
But
main. What was that?
That's it. Just in reality, prepositions don't matter. It could be trial with jury, trial by jury, trial alongside jury. It doesn't matter.
I would have to disagree.
I guess
So like,
I'm kind of curious. I'm kind of curious about that. Like, where is the difference here coming from? Like, as far as trial by jury, trial with jury, where is that? How does that exist? What is the difference that you're claiming here?
So I was just about to point out to that, and John did go over it. He just didn't maybe share my perspective on it. So basically, I'm saying, like, when he describes, like, there's times that he disagrees with, times where, like, it's not justifiable, right? Even under the laws, even under the reasonings for, like, prejudice or whatever, you know. Now that is what I would say is a trial with jury as opposed to trial by jury, because there's no justification for it, right? So at that point, they're basically trying to fool you that you are getting the trial by jury, even though you might have evidence that was withheld from the jury that followed the rules. And I would say that in reality, like you guys were saying, like, there's a difference between the reality of it. In the reality of it, it would be a trial with jury.
So if a judge makes, let's say a judge blatantly disregards the rules of evidence and it's something that screws the defendant over, results in a conviction because of that. If that happens, and believe me, I have some issues with the appellate courts too, but there is a remedy of appealing the conviction after it happens and saying that the judge violated the rules of evidence here, wrongfully decided this, that it prejudiced the defendant, and that it should be remanded for a new trial. There are appellate courts that often, I like to think of it as a cop-out most of the time, where they'll say, yeah, the rules of evidence were incorrect here, or the judge was incorrect here about the rules of evidence, but we don't think there was a good chance that the ruling impacted the verdict. That is a cop-out appellate courts use a lot. I think they overuse it. If that excuse is used, I don't think it should be used anywhere near as often as it is. But as far as that goes, that's about appointing better judges or electing better judges, depending on what kind of state you're talking about and what kind of judicial level you're talking about.
Or maybe even the education too, right?
Say that again?
Or maybe even the education too, right? Might be lacking.
So yeah, I mean, there's definitely judges that are wrong about things. The idea is usually supposed to be that an appellate judge or a Supreme Court judge, whether we're talking about state or federal, is supposed to have a lot more experience and know what they're doing. But trust me, I mean, I've seen them mess up before too. I mean, the part of that is just that people are just not perfect. They're going to make mistakes. They're going to have dumb reasoning for things. Part of it is that judges sometimes will just make a ruling because they want to make that ruling. I mean, we've definitely seen that with the United States Supreme Court before, where people will just vote based on kind of what they want rather than what their actual interpretation of the law is. I mean, that just kind of comes with the common law system and having judges. There's always going to be some sort of bias there and some sort of mistakes that are going to happen. But that doesn't necessarily mean that there wasn't a trial by jury or that the constitutional right to trial by jury was violated when the appellate court decides that the conviction should be upheld, especially because, and I'm not saying I agree with this, my view of how things are is different than how I think things should be. But in a common law system, precedent matters so much that when a higher court, whether we're talking about appellate, Supreme or appeals court, Supreme Court, whatever you're talking about, makes a ruling, I mean that it is like a statute has been passed, unless it's overturned by that court at some point in the future, or it's overturned by a court with a higher authority there, because that's how common law works. It's not everything has to be codified. So much of it is based off of prior orders and decisions from courts.
Right.
What were you going to say? I was just going to say that our tech guy does have to leave in about 5 minutes. So if there's anything else you want to cover real quick, we can. I'd be happy to do this again sometime if you wanted to too. If you had anything else you wanted to talk about, because I know we could probably go on all day. But I did just want to let you know that so we could try to wrap up in like 5 minutes or so.
I think really the only thing we haven't covered is like how this relates to the real world. Like in the real world, courts are not going to accept sovereign citizen arguments at all.
I did kind of cover that though, right?
Yeah, I think we did kind of cover that, because my point there was like, so David, let's talk about, or I want to use the example of what you talked about how judges often will make bad evidentiary rulings and they will screw defendants over, and maybe the appeals court will also make a bad ruling. And there's been times where I've thought, and I'm sure you would think too, that the ruling was bad and that it violated a defendant's rights, and ultimately they have no recourse for it at that point because they've already went through their appeals. If something like that could happen, why do you think that wouldn't just happen for the arguments that the website you're citing is making? Because if the courts, if you think, and I'm not saying you think this, but if you think there's some kind of grand conspiracy here among judges, attorneys, etc., to kind of suppress this kind of stuff, why is it that the judges would have to listen to it in the first place? Because a trial court judge could just make their decision, and you or the website you're citing could think it's wrong, and then the appeals court could just do the same thing and just affirm the trial court's decision. And then unless the Michigan Supreme Court or whatever state Supreme Court or federal Supreme Court you're talking about wants to take it up, that's kind of the end of the road.
I believe basically it's golden shackles. They want to give us the illusion that we have rights and freedoms when we really don't. Just government granted privileges, basically.
And I don't disagree that government is tyrannical and does all sorts of awful things, but I don't think there are magic words or secret things you can do to get them to stop, especially when it's ultimately going to come down to what the trial court judge rules and then what the appellate court or any higher court judge rules there. I mean, if there is some sort of grand conspiracy to shut down proper legal arguments, they wouldn't have to, the judge and judges are involved in this. If you're saying that, they wouldn't have to acknowledge what you believe to be the correct arguments, even if you brought them up. They could just say, no, we're not dismissing it for that. That's wrong.
I don't know. I might have to disagree. I think that um, if they want to keep their job, you know what I mean, and keep the U.S. government going, you know, I mean, there's only so much the people's gonna take. I mean, if you eventually tell them that their last right has been taken away, I mean, what's that gonna lead to? You know what I mean?
Right, but I think you would agree with me that most people do not see the general sovereign citizen arguments as legitimate. So I don't think there's going to be a huge outcry if those kind of arguments from like the average person, if those kind of arguments are thrown out or disregarded by a judge. So if it comes down to what the trial court judge agrees with, what any appellate court judge agrees with, why wouldn't the judges just say, oh, no, we do actually have jurisdiction, and here's a reason why? Because trust me, they can come up with all sorts of different arguments and just disregard the argument that the person is making, especially when a large percentage of the population does not think those arguments are legitimate in the first place.
Yeah, I mean, I get that, and that's kind of what I touched on before, like with the trial by versus trial with jury. I mean, they try to fool everyone basically into believing that it's something that it's not. And I'm not saying that that shit, I forgot where I was gonna go, but it was something to Jeremy. About
in
it.
there. I'm good at that.
I think,
So I'm totally losing my
I
thought
think,
train.
Yeah, I always lose my train of thought.
I've done it in court. It's not fun.
I mean,
Yeah.
like, do you think they're really going to trick the whole American people, all 330 million of us, or however many there are here, by changing a preposition?
I don't think they'll fool everyone, right? But and I think where I was gonna go with it was like you were saying that it isn't real. I mean, entertain that it is real, though. You know what I mean?
Yeah, but I could also entertain a lot of things, but I'd like to entertain what's real.
Yeah, me too. And that's what I'm trying to get at. Like, I think John had said something earlier about I can't remember the point I was gonna go with, but
You're
it was
saying
something.
entertain if it was real.
So like we were saying before, it's not like that. It's real. It's not real. I feel like it is real. Like it's in the history. It's not secret. That's where I was gonna say too. It's not like secret knowledge. Anybody could go and read it. It's just majority of the population isn't going to. You know what I mean?
Yeah, and you can absolutely argue that there have been decisions or cases wrongfully decided, because I mean it's impossible not to argue that, especially because there have been cases with completely differing holdings that contradict one another. So there are definitely different interpretations of law. I would definitely agree that there's current case law that I think is completely incorrect, not based on constitutional principles, not the correct interpretation of the law. But that argument on how things should be or how things should be interpreted, it's different than the argument of what actually will work if you're in court. Because even if you think something shouldn't be the way it is, and believe me, there are a lot of things that I think shouldn't be the way they are, especially in the criminal justice system, I can't just go into court and say, Your Honor, this is a dumb law, and this prosecutor's being an asshole. He probably hasn't even looked at the case yet. Just throw this case out. Like that won't get it done. As much as I'd like to, that won't get rid of the case. So there's a difference between
motion to dismiss for being poo-poo stupid.
Exactly. So there's a difference between what actually works and how I'd like things to work, or how I think things should be.
Yeah, I get that. Yeah, I don't know.
Well,
I think that.
Tell you what. So our tech guy does have to leave in a few minutes. We'd be happy to have you on another time. I'm going to give you the last word in case there's anything you want to say, or in case there's anything you want to plug before we go for the day.
Yeah, I mean, I will definitely love to continue it. There's a lot that I didn't get to go on. I think we kind of drifted from it at some points, but yeah, I'd definitely love to come back on with you guys. You guys seem like pretty cool people.
And thanks for coming on. I know it took some courage to come on for sure. I'll absolutely give you that. We've had obviously we disagree about some things, but we've had a good discussion today. So we appreciate you coming on, and I'm happy to address anything we want to talk about in the future. So I'm gonna wrap up here. Thanks everyone for watching today, and thanks to David for coming on. And we will see you again soon.
See ya.
Yes.
Take care.
Take care.
Buy shirt, get money. No, other way. We get money. You send money, we get shirt.